A US judge on Thursday said he is leaning toward releasing some of the evidence presented by the US Justice Department to justify its search of Donald Trump's Florida home last week, in a case pitting news organizations against federal prosecutors. Despite objections by the Justice Department, US Magistrate Judge Bruce Reinhart said he believes there are portions of the affidavit that could be unsealed, referring to the sworn statement laying out the evidence for why there was probable cause to search Trump's Mar-a-Lago resort. He ordered the Justice Department to file a redacted version of the affidavit under seal by noon next Thursday, but said prosecutors will be given the opportunity to appeal if they don't agree with his proposed version.
I feel good about today's hearing. Judge Reinhart seems to have a very good sense that it is his job as the gatekeeper in this case to perform his function of balancing the interest in the public of accessing these materials against the interest in the government in keeping them secret. Judge Reinhart gave us some clues to that today by telling us, for example, that at this juncture he is not inclined to keep the entirety of the search warrant application and its affidavit under seal, meaning that he understands that the public is going to likely be entitled to some parts of this warrant application and its affidavit. He will consider redactions proposed by the Department of Justice, which are due to him August 25th. He will accept any briefing of the Department of Justice on those redactions. He will review those materials, and he will enter an order specifying what information, if any, will remain sealed and inaccessible to the public.
Reinhart's order seemed to mark a victory for news outlets who appeared in federal court in West Palm Beach on Thursday to persuade the judge that the public interest in the affidavit outweighs the benefits of keeping it sealed.
I think Judge Reinhart is going to protect the identity of confidential informants, and that's probably the right outcome here. We don't want, none of the media interveners want to jeopardize the safety or security of a confidential informant. It is very common in these situations that information that would lead to the disclosure of their identity is kept secret. However, it is important to note that simply saying somebody works for a particular agency is not sufficient. Perhaps saying their title, their post, the number of years they've been in position, and other identifiers may get us there, but the generic fact that there are confidential informants working with the government is not something that I would think is subject to protection. Today what was unsealed is the motion to seal the search warrant, which you all have, the underlying search warrant, and the order on the motion to seal the search warrant. I would expect the motion to be fairly generic and describing that we have a search warrant, Your Honor, that we would like you to seal, and I would expect the order to be fairly generic. We agree that your search warrant should be sealed.
The search marked a significant escalation in one of the many federal and state investigations Trump is facing from his time in office and in private business. The Republican former president has suggested he might run for the White House again in 2024, but has not made any commitment. The Justice Department opposes the release of the Mar-a-Lago affidavit even in redacted form. Jay Bratt, the head of the department's Counterintelligence and Export Control section, told the judge on Thursday that releasing the affidavit is not in the public interest because it could harm the ongoing probe, which he described as still being in the early stages and involving high-sensitive grand jury material. There is another public interest at stake, and that is the public interest that criminal investigations are able to go forward unimpeded, he said.
For those of you who are not inside the court hearing, Judge Reinhart actually put forth a procedure that he's going to use in this case. So August 25th, the government will propose its redactions, the search warrant application, and its affidavit. They can also file a brief at that time explaining why they are requesting the redactions. At that point, Judge Reinhart will review the requested redactions and review the documents, and he'll make a decision. If he agrees with the government, he'll enter an order agreeing with the government, and we will get whatever it is that the government and he have determined should be released. If he disagrees with the government's requested redactions, Judge Reinhart is the ultimate decision maker here, so he will enter an order disagreeing with the government's redactions, but give the government time to appeal that order before he releases the search warrant and its affidavit. Because, of course, if he didn't do that and it became public, the government would essentially lose its right to appeal. So if he disagrees with the government's redactions, he will give the government a chance to appeal that order before he releases the warrant application and its affidavits for the public.
The search, which was approved by Reinhart on August 5, is part of a federal investigation into whether Trump illegally removed documents when he left office in January 2021 after losing the presidential election to Democrat Joe Biden.
Nobody mentioned the waning credibility of the FBI specifically. However, Mr. Tobin did make the argument that this is a proceeding that's about the credibility of all the players. So whether the judge is doing his job, whether the DOJ is doing its job, that is the proper function of these access proceedings and why the public is entitled to access. That is the public interest. We are entitled to monitor the affairs of our government at all levels, and that is the interest in this essence that we were asserting today.
The Justice Department is investigating violations of 3 laws, including a provision in the Espionage Act that prohibits the possession of national defense information and another statute that makes it a crime to knowingly destroy, conceal, or falsify records with the intent to obstruct an investigation. Attorneys for several media outlets, including the New York Times, the publisher of the Wall Street Journal, ABC News, and NBC News, told Reinhart on Thursday that the public's right to know and the historic significance of the search outweigh any arguments to keep the records sealed.
The government, the DOJ, had agreed to release certain materials prior to today's hearing, so Judge Reinhart took care of that off the top. First and foremost, he agreed with the government that the search warrant, motion to seal the search warrant and the order on that motion should be released. For those of you who are interested in receiving it, that is at docket 57 in the case, and it should, if not already has been unsealed. It will be unsealed today without objection from the DOJ.
Trump has vocally made statements on social media calling on the court to unseal the unredacted version. However, his attorney have not filed any such request with the court seeking to unseal the records, which are likely to contain damaging information about Trump. Christina Bobb, the Trump attorney who signed the warrant material on the day of the August 8 search, appeared in the courtroom on Thursday to watch the proceedings. She left without making any statement to reporters.